The Supreme Court of Appeal has granted Home Affairs Minister Dr. Motsoaledi leave to appeal the Zimbabwe Exemption Permits ruling this after the Zimbabwe Immigration Federation took the Department of Home Affairs to court in 2022 over the termination of the ZEP, asking the court to declare it unconstitutional and invalid. The termination of the Zimbabwe Exemption Permit program raises concerns about leaving thousands of Zimbabweans undocumented, along with thousands of children born in South Africa, to parents holding the permit. Motsoaledi says the department is ready to appeal. We discuss this further with Dr. Dale McKinley of Kopanang, Africa Against Xenophobia. A very good evening to you, Dale. Thank you so much for speaking to us. So, the Supreme Court of Appeal granting the minister leave to appeal the Zimbabwe Immigration Federation matter, which has to do with the ZEP, as we mentioned. How does it differ from the Helen Suzman Foundation matter, which appeal the minister lost?
Well, I mean, obviously there are two separate cases. I mean, they were filed separately and different kind of arguments and others. But in the context, I have not read exactly the legal papers. But my understanding is that in this case, the Supreme Court of Appeal has decided that there are possibly grounds. If they're granting leave to appeal, then the legal principle is that the Constitutional Court in this case could come to a different conclusion, or that there could possibly be a different interpretation of the law. They obviously did not feel that that was the case in the Helen Suzman Foundation, and they feel in the Federation case that there might be obviously some aspects of this case that are different, or that might be arguable in the Constitutional Court around those constitutional matters. And I think in this case it is a bit confusing. I mean, for a non-legal expert, in terms of the different kinds of orders here, because it is the same issue. But my understanding is there can be different legal arguments being made, and that's why the SCA granted the leave to appeal.
So just looking at the ruling that found in favor that the ZEP termination was unlawful, unconstitutional and invalid, did that have to do with the lack of consultation?
Well, that certainly was one of the main reasons. If you looked at that ruling, much of our legislation and the mandate that's given to the Department of Home Affairs when they pass these kinds of regulations, legislations, they must have meaningful consultation, and the argument was made that they didn't do it, and that was accepted. So yes, I think that was a crucial component. What could be different now, and I guess this is up for debate because that's why you have appeals processes, is now we're many months on. The extension that the ZEP has been extended by the Department of Home Affairs as a result of the previous legal challenges and cases until the end of this year. So, in fact, it's the second extension. But they're still, I think, wanting, the sense is, at least the sense that we have, is the Department of Home Affairs wants a legal victory. They want a legal interpretation that they have the right to do these things, and they have the right to actually make these determinations. And they're saying now we've done all of the consultations, we've extended this, so it's a different matter now. And that's a debatable proposition, but it's one that should be argued before the courts.
And I want to get into that. I mean, the Pretoria High Court ordered Minister Motsoaledi to reconsider the termination of the program following what it called a fair consultative process that complied with the relevant laws. But what are the parameters that would satisfy those conditions in your reading of what the order says?
Well, I mean, there has to be certainty. I think that was the main thing. I mean, the argument that was made is all this back and forth, and this, the unilateral decisions, and then the cutting off basically puts most of the Zimbabweans that are affected into total limbo. It puts them into legal limbo, social and political and otherwise, and in their entire lives. And there needs to be a certainty to these kinds of things. And this process, this legal process back and forth, doesn't provide any certainty. So we still don't know, because there hasn't been a fundamental ruling. What has been ruled is that Motsoaledi didn't do his job properly, and therefore he can't do what he did. he must go back to the drawing board and do it properly. Now he's saying, I've done it properly, I've done all what you've asked for, but I want a ruling in this case that gives us the right to basically end the permit and to do so on our own terms. And this is what's going to be argued. So in many ways, there's a legal conundrum here, at least I'm not a legal expert in this case, but from our perspective, what would be necessary would be a final ruling in the court to say, yes, you have the right to do this, and this is when you must do it. Or no, you don't have the right, and you must go back to the drawing board and redraft the legislation accordingly. That would essentially, I think, then give certainty specifically to those that are affected, in this case, the holders of the permits.
So you just listed some of the challenges in terms of the assessment that's been made to determine the impact of the ZEP holders on their children or even themselves. But, this has become one of those contentious issues. It's fallen right squarely into the ambit of political parties with regards to policies to do with foreign nationals or migrants. So in your view, beyond the uncertainty, I'm just looking at the regulations from a policy perspective. It's an issue that is firmly within the political economy as well. What benefit is it for South Africa, the Zimbabwe Exemption Permit? What is it for Zimbabweans who actually acquire this? And this assessment, will it have to be made anew when there are these consultations going forward?
Yeah, well, from our perspective, obviously, it's a bad decision. And the first, it's a political decision. We don't think it has anything to do with the practical realities of the situation. If you rationally, whether it's South Africa or any other country, what you have is a situation where immigrants, mostly skilled immigrants, mostly immigrants that are quite professional, that have jobs, that were granted permits on the basis of having those jobs, of contributing to the economy, of paying taxes, of doing all the things that normal citizens would do. And that made rational sense. Now, all of a sudden, we have a situation where, because of the political changes, because of rise in sort of xenophobic sentiment, particularly with other kinds of things, and the seems intent on proving himself to confuse legitimate immigrants and those that have followed the law and those that have done, and those so-called that have not, and that have engaged in sort of illegal activities and others, and basically paint everybody with the same brush and say then must all leave. It's not a politically and it's not an economically smart decision. So irrespective of the legal arguments, it makes no sense for us to do these kinds of things. If South Africans, in this case, are worried about people who are coming in and taking advantage of the system, deal with those people. Make sure that you were just having an interview with yourself about corruption in the department, about things that are going on. In that sense, there needs to be a cleaning of the house itself before you go and you start maybe victimizing people who have done absolutely nothing wrong. And I think it's not a legal argument, but it's certainly a political and social argument that makes much sense. And it shouldn't be the case, whether it's Zimbabweans or any other nationality, that people are punished for following the law and trying to contribute to our economy and to our country.
Always a pleasure to talk to you, Dr. Dale McKinley, Kopanang, Africa Against Xenophobia.